So one of the best things about argument this week was that it was before a fully packed courtroom. Every seat was taken. There were so many. There were former CMU prisoners. There were current plaintiffs. There were family members of current CMU prisoners. There were folks coming out from the Muslim community who have been concerned with this issue since the CMUs began in 2006. There were so many activists and advocates and prison experts, and it was just a really exciting thing to be able to show the court, this matters to a lot of people. So the district court in the case basically held that prisoners who are put in a CMU don't have a liberty interest in avoiding segregation in these restrictive units. And that's because the court compared conditions in a CMU to conditions in administrative segregation, which is a harsh form of solitary confinement, really, that the Federal Bureau of Prisons uses all the time to segregate prisoners from the rest of the prison population where there's a potential security concern. So what we were arguing to the court this week was that, if you're going to compare segregation in a CMU to segregation and administrative segregation, you have to do that with a complete understanding of the facts. And what we were able to do in this case for the first time ever is gather evidence about the way the Federal Bureau of Prisons uses administrative segregation. And we were able to show to the court that administrative segregation, while it's very harsh, is very short-lived. So a typical stay in administrative segregation is 1 to 4 weeks. 1 to 4 weeks in restrictive confinement. And that the court has to compare that to our client's experience, who spent 3 to 5 years in a communication management unit where they were banned from any contact visitation with their loved ones, and all forms of communication with the outside world are restricted. Now, we were also arguing to the court that procedural protections are especially important before putting individuals in a CMU because of the way in which the CMUs are used discriminatorily against Muslims in the prison system. There are about the CMU population is about 60 to 70% Muslim, compared to a Muslim population in the prison system as a whole of 6%. When you have that vast an overrepresentation, it's incredibly important for there to be some procedural protections. The appeal has been submitted to the circuit court, and we're hopeful that the circuit is going to reverse the district court and send the case back down for the district court to consider whether we should win summary judgment or whether the case needs to go to trial. And we'd probably just expect a decision in the next 6 months or so. A couple of the judges sort of on their own brought up the issue of contact visitation, which of course is an important legal point for us. The CMUs ban all contact visitation. That means, when you visit with a family member, it's through glass. It's especially devastating for parents trying to visit with their children. And it's something we've talked about in our briefs, but the fact that the judges focused on it as that being a particularly harsh part of the CMU experience, I think to me really underscored that they were looking at the individuals involved as human beings, not as sort of just prisoners who they don't care about. And I think having that sort of talked about in court was important to family members. We spend all this time preparing for argument just, focused on the legal issues and reading cases and rereading our briefs, and it's exciting to get up there and to be able to make your case and know that, the folks who you're representing, who you're fighting with, are there with you.